Hello, and welcome to an episode that talks about media trials. I'm Swati Singh, a media professional for the last 10 years, specialized in mass communication. I have worked as a journalist with the Hindustan Times, Indian Express, and Career Launchers, etc. And I've also taught print and electronic media in various universities and colleges, including the Delhi University. Today, we shall be discussing trials by media or media trials, the fairness of the trials, holding debates and discussing the stand of the Indian courts with respect to media trials, etc. All this would be discussed in detail. Let's start by discussing the objectives of this episode. Well, the objectives of this lesson include to understand the meaning of media trials, to understand if the media trials are fair trials, to talk about the restrictions by Constitution on freedom of expression, to learn about media trial versus judiciary, to learn about media trial versus fair trial, to learn about the stand of the Indian courts with respect to media trials. Let us start by addressing the agenda of media trials. Trial by media is a popular phrase which is equal as to the statement that whosoever controls the media controls the minds, that has been used popularly in the last few decades to describe the impact of television and print media coverage on a case by an attempt made by the media of holding the accused guilty, even prior to his trial and regardless of any verdict in the court of law. The criminal jurisprudence followed in India is based on the theory that an accused is entitled to fair trial and is innocent till proven guilty beyond any reasonable doubt. On account of exclusive coverage, media goes a long way to cover and publish interviews of witnesses, victims' relatives, comments on the member of legal fraternity, etc., which may cause prejudice to a trial proceeding, in particularly the judicial mind. In fact, this affects the perception of the public at large because media reaches out to the masses promptly. In the last decade, we have witnessed rapid growth of media influence in the process of access to justice in plethora of cases relating to corruption, rape, murder, sexual harassment, terrorism, etc. Media activism imposes an indirect pressure on the adjudicating authorities to deliver justice to victims who may interfere with the trial proceedings and may cause prejudice to the accused and the chance of proving his innocence. So, what do we mean by a media trial? Well, trial by the media means the impact of the newspapers and television coverage on the person's reputation by creating widespread perception of guilt, regardless of any verified verdict in court of law. In order to attract more viewers, the media ends up maligning and tarnishing the image of mere suspects and tagging them as guilty even before the judge. Media, by emphasizing on one-sided allegation and taking the easy route of just fueling the public outrage without trying to unearth the reality, can be very damaging, which is barely considered by the media. Media has a great influence over the public of the country. Newspaper, news channels, radio, and television don't only spread the information, rather, they also assist in controlling the stories which the public may discuss later. Crime receives wide coverage, which makes it challenging for the prosecutors and attorneys. The judiciary and the media share a common bond and play a complementary role to each other. Man is the center of the universe. While the media explores, discovers, and reveals the achievements and follies of man, the judiciary deals with legal problems created by him. Both the judiciary and the media are engaged in the same task, that is, to discover the truth, to uphold democratic values, and to deal with the social, political, and economic problems. The media, in fact, has been called the handmaiden of the justice, the watchdog of the society, the judiciary, the dispenser of the justice, and the catalyst of social reforms. Thus, both are essential for the progress of a civil society. However, at times these two pillars of democracy are at loggerheads. Under the fundamental right of freedom of speech and expression, the media claims the right to investigate, to reveal, to expose, and to highlight the criminal cases. According to the media, in a democracy, people have the right to know. Therefore, media has a corresponding duty to inform people about the criminal and the crime. It thus demands the right to carry on pre-trial publicity. Yet, on the other hand, the judiciary is keenly aware of the fundamental right of the accused to a fair trial and of due process of law. Since pre-trial publicity can derail a fair and a speedy trial, the judiciary has to balance the competing fundamental rights. While the freedom of speech and expression of the media, the right to know of the people needs to be protected and promoted. The right to fair trial of the accused needs to be secured and guaranteed as well. Media is regarded as one of the pillars of democracy. It has wide-ranging roles in the society. Media plays a vital role in molding the opinion of the society, and it is capable of changing the whole viewpoint through which people perceive various events. The media can be commended for starting a trend where the media plays an active role in bringing the accused to hook. Free speech and expression is perhaps one of the most important and useful rights available in our Constitution. Freedom of expression, incorporated in the Indian Constitution under its Article 19(1)(a), grants freedom of speech and expression to its citizens. The freedom of press is necessary element of the freedom of expression and involves right to receive and impart information, without which democracy becomes an empty slogan. But this right is not absolute and is subject to the reasonable restrictions of the defamation and contempt of court, among other mentioned in the clause 2 of the above mentioned article, which clearly states that this right can be restricted by law only in the interest of the sovereignty and integrity of the country, the security of the country, friendly relations with foreign states, public orders, decency or morality, or relation to contempt of court, defamation or incitement to an offence. The media pushes people to produce the verdict of the criminal proceedings. Some people use the media to influence the court case outcomes. In media trials, the media serves as a conveyor for popular sentiment. The media are used to practice the parallel elements of justice outside the confines of the courtroom. Let's understand trial by media, fair trial or not. Litigation is not always search for the truth. According to a philosopher, Charles Taylor, it is a zero-sum game, where the law only says either A or B is right. Media trials have always been given rise to a certain kind of problem, as it involves a tug-of-war between two different principles, which are the free trial and the free press, both in which the public at large is generally invested. The freedom of the press is a part of democracy in any country. This is the kind of justification given to investigative journalism. But at the same time, the right to have a fair trial is a basic right, and that is given to every accused and the victim alike, which is uninfluenced by any external source and is thus recognized as a basic tenet of justice. It does not consider the multitude of truth and complexity of events, issues or individuals. British Marxist Terry Eggleton puts it in perspective. Courtrooms, like novels, blur the distinction between the fact and fiction. The jury judge not only on the facts but between rival versions of them. This was published in The Guardian on 25th May 2005. When trial by the court itself is inherently problematic, in the adversarial system of justice, a media trial poses additional issues. Hate campaigns, accusations, and witch hunts impact the judicial process enormously. They also contaminate the cultural and intellectual ecology of the nation. Trial by media in their own eye may be fair, as everything is fair in love and war, because they work on this principle only. Media have the ability to cause a trial by media because the public look at the media as reliable source of information. This was also held by the English court in the case Johnson 2016. Therefore, media acts as a public court or a janta court where they decide the culprit soon before the commencement of the proceedings. It is apparent that media's consistent reporting on a person who is convicted in a trial forces the public to make perception for that person as an accused, which results in the guilt of the accused before proceedings even begin. Hence, the trial by the media is not as fair as they have no power to interfere and to force the public to make an opinion against any individual. The media, by doing the pre-trial interferences in the procedure and mechanism of the judiciary, which is not permissible under any law or act. So let's understand the reasonable restrictions by the Constitution on the freedom of expression. Everything in this country has a limitation to its nature, be it a right of freedom of. Similarly, the freedom of speech and expression, as guaranteed under Article 19(1)(a) of the Indian Constitution, has also been restricted with certain reasonable measures under Article 19(2) of the same Act. The Clause 2 of the article says that the state has the power to make any law to impose any restriction on the freedom of speech and expression, and on the same page, no one is allowed to use this right as against the sovereignty, integrity and security of the nation, or against any friendly nation with other states, or against any public order, defamation and incitement to an offence, or decency or morality in relation with the court. The Constitution has provided these reasonable restrictions to safeguard other fundamental rights over one's freedom. The preamble of the Constitution also mentions that every individual has the right to live a decent life and to have a fair trial by the media is busy with their own trial process. They didn't care about the perspective or the opinion which will be created by their act, or what grievance can be faced by the person against whom they have used their power. Pandit Jawaharlal Nehru, the first Prime Minister of independent India, said, "I would rather have a completely free press with all the dangers involved in the wrong use of that freedom than a suppressed or regulated press." But he did not foresee the danger involved, as he did not expect the press to get involved into something which is beyond its limitation and ethics too, and which further hinders the administration of justice, which is the very essence of the natural justice and the rule of law. Constitutionally, the press in India has no special rights, said Dr. Ambedkar, but a free press is a political imperative for democracy to survive. In a criminal trial, the prosecution and the accused have the right to a fair trial. Between free speech and fair trial, the borders are sometimes crossed and the rules breached, leading to devastating consequences to individuals and institutions. The debates on television should not be allowed to meddle with a trial in accordance with the law. The digital violence in itself is a breach of peace. Media is an institutionalized anarchy in a liberal and positive sense. Media trial definitely falls under the ambit of the contempt of court. Thus, it should be made punishable. The right to fair trial must be uninfluenced by the newspaper publications or even the headlines of the news. But what happens when the leading news channels decide to go against the ethical code of the contempt? Then decide to sabotage the career of the accused even before his guilt is proven in the court of law. They portray him as an evil person during the prime time when all the viewers are generally geared in front of their television. It is important to note that the idea of democracy is fair play and transparency, and by such an act of the media, the contempt of democracy is at stake. Thus, any attempt made to sabotage the other pillars of democracy by one of them must be held as contempt. Let's discuss media trial versus the judiciary. So, there's been a low legal system where the media is given the power to try a case. Every coin has two sides to it. So is the case with media trials in journalism. At certain instances, journalists portray a pre-decided image of an accused, thereby tearing his reputation that can eventually affect the trial and the judgment, henceforth trial by media. In India, media trials have assumed significance. There has been several cases where the media has taken the case into their own hand and declared the judgment against an accused contrary to the fair trial in the court. The media can even influence the thinking process of any individual. Like for an example, like in these time of COVID-19, it has been a whole world pandemic. The media and news channels every morning will telecast how many people died, number of new cases, which automatically creates a lot of fear in a person's mind. Whereas, if they show number of recoveries, this might motivate the public and help them find the pandemic more effectively. Media changes the view of the people, which can have both negative and positive impacts. The media does nothing but just manipulate people's mind. Recently, the country has seen uproar and shown its grave concern in the sensational case of the late actor Sushant Singh Rajput on the issue pertaining to the investigation and alleged mishandling of the latter's unnatural death. The media has narrated an entire story of the late actor's death in a manner so to induce the general public to believe in the complicity of the persons indicted. The media has gone a step further and published information based on mere assumptions and suspicion about the line of investigation by the official agencies to vigorously report on the issue on a day-to-day basis and comment on the evidence without ascertaining the factual matrix. Such reporting has created undue pressure in the course of fair investigation and trial. The media in this manner is conducting a parallel investigation and trial and has already foretold its decision, thereby creating a pressure on the investigation agencies. In connection to the case, the court asked if the current mechanism for self-regulation of the electronic media was enough to maintain a balance between right to freedom of speech and expression and the right of the accused to a free trial and reputation. A division bench of the Chief Justice Dipankar Datta and Justice Girish S. Kulkarni was hearing PIL filed by the 8 former senior police officers from Maharashtra as well as activists, lawyers and NGOs seeking a restraining order against media trial in actor Sushant Singh Rajput's death case. The court said that in the present case, substantial damage has been caused to the reputation of the person so-called involved. It takes years of hard work to build a reputation, and with just one stroke, it is brought from top to bottom. Without being punished, there is stigma on the forehead till the trial is completed, no matter if they are cleared of the charges, the court said. Well, what is media trial versus fair trial? Let's talk. Pre-trial publicity is injurious to the health of a fair trial. The media trials have also pressured the lawyers not to take up cases where the public deems certain individuals as guilty without actually being proven due to the media trials, thereby forcing the accused to withdraw his right to have an advocate, but it also dissuades the advocates who actually take up such cases. The media has again come in focus in its role in the trial of Jessica Lal murder case. The concept of media trial is not a new concept. The role of media was debated in the Priyadarshini Mattu case and likewise many other such high-profile cases. There have been numerous instances in which media has been accused of conducting the trial of the accused and passing the verdict even before the court passes its judgment. For example, in the case where the senior advocate Ram Jethmalani had defended accused Manu Sharma in Jessica Lal's case. It was during this time that one of the senior editors of a TV news channel stated that it to be a defense of the indefensible, thereby declaring that the accused was already guilty of the crime he had not yet been proven of. The assumption of the media clearly encroaches upon the right of the accused to have a fair trial, as well as his right to have a good advocate. Jessica Lal murder case, that is Manu Sharma versus the state NCT of Delhi, the court held that despite the significance of the print and electronic media in the present day, it is not only desirable but the least that is expected of the person at the helm of the affairs of the field to ensure that the trial by media does not hamper fair investigation by the investigating agency and more importantly, does not prejudice the right to defense of the accused in any manner whatsoever. It will amount to travesty of justice if either of this cause of impediment in the accepted judicious and fair investigation and trial. Journalists are free to investigate, but they cannot pronounce anyone guilty or prejudice the issue or prejudice the trial. The grant of the fairest of the opportunity to the accused to prove his innocence is the object of every free trial. Conducting a free trial is beneficial both to the accused as well as to the society. A conviction resulting from an unfair trial is contrary to the concept of justice. Now let us talk about the stance of the Indian court with respect to the media trials. In India, the courts have the power to pass pre-publication or pre-broadcasting injunction or prior restraint orders in subjudice manners. The two-pronged test of necessity and proportionality has to be satisfied before ordering postponement of publication. Moreover, the injunction order should only be passed if reasonable alternative methods or measures would be to prevent the said risk. Before airing any such story pertaining to the plaintiff and the defendant shall give the plaintiff a written notice by the electronic mode, asking for his version. If the plaintiff refuses or does not reply within a reasonable time, he will not be compelled to speak, and the story will be aired with the disclosure that the plaintiff has refused to speak to defend. The Press Council of India Act constituted a body named the Press Council of India. It is a statutory autonomous body, and its objective broadly was to preserve the freedom of press. The council could warn, admonish, or censor a newspaper or a news agency for any professional misconduct or breach of the code of journalistic ethics or offences against the public interest. It could also condemn the government or other organizations for interfering with the freedom of press. The PCI enjoyed the same powers while holding an inquiry under the PCI as invested in a civil court while trying a suit under the Code of Civil Procedure. The council could also ask a defaulting newspaper to publish the council's findings. The council is empowered on complaints made it or otherwise against defending newspapers. It is comprised mainly from the newspapers that are charged with the responsibility of regulating the Code of Britain. The council has thus assumed the role of self-regulation body of the newspaper themselves. The council has the power to consider complaints suo motu, in addition to inquiry into the complaints brought therefore before it. It has empowered to make observation against authority, including government, if it considers it necessary for the performance of the functions. Thus, the Press Council is a statutory, quasi-judicial and self-regulating body without teeth. The power of Press Council of India is limited and increases the tendency of the media sensationalism and competition among the newspapers, which accelerated media to deviate from their traditional accountability and ethical values. Consequently, the invasion on individual right as well as collective right is rising. Thereby, a need for a strengthened statutory body is need of the media world. Let's come to the conclusion. Media are principal pillars of democracy across the world. The media plays numerous roles in the society, including molding social opinions and perceptions of specific events. In recent times, the media has played a role in pushing for the trial of accused people. The media informs the public on matters of significance to it, meaning that a healthy and free media are critical to the working or functioning of democracy. Not only the freedom of press is subject to the laws of the land, such as contempt and libel, but also it is responsible to the society it serves. It should accept certain responsibilities in the discharge of its duties and functions. And now it's time for a quick recap. Today we discussed the meaning, problems and tribulations related to media trials. We also talked about on how media and court complement and at times clash on various cases. Well, that is all we have for you today. Hope you enjoyed the session and learned about the importance of media trials. We shall return with the second part of the media trials in another interesting episode. Until then, farewell and namaskar.